We've got Ishana Tripathi. Ishana over here is from India and Jindal Global Law School. She's a professor of corporate insolvency and contract law. She's a graduate of Nalsar University in Hyderabad, University of Hamburg, and Erasmus University. And Haemin Lee from Korea is at Seoul National University. She's an assistant professor in commercial law, and she's just astonished me by telling me that she was a judge for 16 years before she went into academic life. We've also got Chitra Latha from Monash, Malaysia, here in spirit. She had a conflict and couldn't be with us, but I've got a few comments from her. So I want to start off just by way of background in terms of capital market structure differences across the jurisdictions. And of course, we just had Royhan telling us about, this prediction that, in the Laporta study, that the world would inevitably go towards dispersed ownership a la America and the UK. That really has not happened. The 2025 OECD Fact Book makes it very clear that concentrated ownership is the most common type of model of corporate governance around the world. And that's particularly the case, obviously, in Asia, where you have a controlling shareholder that's either another corporation, family, or the state. So the other difference, I think, across Asia is the level of institutional investment in listed companies. So globally, it's about 47% of total equity holdings are held by institutional investors, but there's a big difference across Asia. So we've got at the top of the spectrum, Australia and Japan, with the highest level of institutional ownership, 32% in each country, and then it goes down. India, we've got 22%, Korea, 17%, Singapore, 17%, although Dan thought that was an overestimation and might include Temasek. Then we've got China, 13%, and we've got Malaysia, 10%. So that's a big spectrum of institutional ownership. And we're going to be passing the mic around, and I'm going to pass it first to Haemin, because Korea is a classic case of concentrated ownership with chaebols. And I know that, as we saw with Japan, with Abenomics, you've had this intersection of legal change and then, flourishing capital markets. So I just wondered if you could tell us a little bit about what's been happening in Korea.
I see. Thank you very much, Jennifer. I just would like to, since this is my first time attending this conference and first time having the microphone, I really would like to thank the organizing committee and everyone for holding such a wonderful conference. I'm really happy to be in this panel. So just has been introduced by Jennifer, just like many other jurisdictions in Asia, Korea has this distinctive feature of concentrated ownership in corporate culture. And this has been pointed out to be one key reason why the minority shareholders are underrepresented in Korea. And this has been concern in many days. And because of the underrepresentation, it has been identified to be the reason why the Korean corporates are undervalued in the stock markets for a long time. And also another distinctive feature, along with the role of the institutional investors, is that the number of retail investors has increased rapidly in Korea, as has been introduced in the Professor Jung's presentation yesterday. And this has turned the capital market issue into a political priority, which made the government to act under the phrase of addressing the Korea discount or the Korean value up. So I really need to draw your attention to the recent Korean stock market success, which made the Kospi index almost double, just as you introduced yesterday. And it seems everyone made money except for Professor Jung and me. So yes, and this is really closely linked to the government initiatives, which was just mentioned. And then this has led to 3 major amendments in Korean Commercial Act last year and this year. And that includes, if I just briefly introduce, explicit expansion of fiduciary duties to all shareholders and mandatory cumulative voting for large listed companies, and 3, voting cap for controlling shareholders in audit committee elections, and regulation mandatory cancellation of treasury shares, and so on. So, and this really is giving clear message to the retail investors and the market, and also the voters. Yeah, thank you.
Either of the other speakers want to talk on this issue?
Thank you. Hello, everyone. I'd like to give you some data about the ownership structure of the Chinese capital markets. And in terms of the institutional ownership or the ownership held by individual investors, there are 99.76% of the shareholders are individuals in terms of the accounts or the numbers of investors. And in terms of the market share of market value, the number is 32.3%. They are held by the individual shareholders. And another prominent characteristic of Chinese capital markets is the concentration of the block holder. The data is that among all the listed companies, over 25% of the companies where their largest shareholders hold over their shareholding is about 60% to 80%. So the concentration rate is really high in Chinese capital market. Thank you.
First off, echoing what Haemin said, this is my first time at this forum, so thank you very much for the organizers for having me. Jennifer posed a tough question on the capital market considerations, but I want to just steer clear and off a lot of reform from a legalese perspective, because India has been notorious for making a lot of reaction-based reforms, which is essentially where governance also sort of plays out, as opposed to holistic reforms, which is changing today, primarily because of the retail investment market. What Haemin has said is also very, very true for India. I never knew the data distinction to this extent till Jennifer posed the question, because India's moved from institutional investor to a more retail investor market. Especially the past 5 to 10 years have been extremely sort of demonstrative of how liquid the market is, and for a jurisdiction that has been viewed by a lot of academics as a low contract enforcement jurisdiction, a trust deficit jurisdiction when it comes to investments and investor confidence. There seems to be a lot of confidence in the stock market that the public has, and clearly with the entire retail investment boom, there seems to be a resurfacing of the idea that there will be a future which is more investor confidence led. And I just want to draw a very brief comparative of EU, US, and India here. Because you see, when you're looking at the United States, you're looking at foreign portfolio investors or foreign institutional investors, who are not necessarily, or a larger private credit hedge fund model, as opposed to a mutual fund-based model that seems to be leading the way to create liquidity in the American market. Whereas the EU stock exchanges in themselves have sort of struggled to find that stock market confidence from the individual investor around, or the mutual fund investor. And when I looked at the numbers with the as of March 31, 2025, you're looking at a 17.62% of stock exchange holding in equity by mutual funds. And that's a huge shift from where India was at about 5 years ago, which was more foreign portfolio, foreign institutional investor driven. Just in terms of reforms, as we speak today, consolidated law is being proposed as a consolidated securities law. Tomorrow there is a presentation at the Parliament, in front of a Parliament Select Committee for global reforms in terms of strengthening governance measures to effectively address a large amount of issues that plague transparency concerns, and to be able to further strengthen investor confidence to allow for more foreign and domestic market investment. And just to sort of end here, one of the things that's very interesting about India is that there is actually a lot of liquidity within the domestic market, which is a huge shift from a lot of other jurisdictions which rely on foreign capital. And based on that, there is a lot of reform that is being tabled to strengthen or repurpose the idea that there is enough liquidity in the market to put money into the stock exchange. Thank you so much.
So I want to just draw on, this idea of concentrated ownership. But at the same time, I think it was you, Jun, yesterday saying what a high level of individual ownership, 40% of adults. I mean, in Australia, it would be much higher as a result of our superannuation pension funds, and that then kind of transforms it into a political issue because, if the stock market crashes, you've got a whole nation that's going down with it. But in concentrated ownership, the agency problem is between, the controlling shareholders and the minority. And so just in terms of recent developments, I think you just touched on the idea of, fiduciary duties developments of directors, independent directors, which has always been a big issue, particularly in India, mandatory cumulative voting, which I think is now a thing in Korea, which, interestingly enough came from John Stuart Mill in the mid-19th century with his book Representative Government, where he said, well, the majority will win out, but hey, it's always good to hear what the minority thinks. So just if you can go around and tell me, what do you think is the key, and also I guess board structure, with greater gender diversity. What do you think are, the real key things in your jurisdiction, very briefly, because we're passing the mic around, that you think really define your particular jurisdiction in the way that they're addressing this agency problem and protection of minority shareholders?
I think it's really a big question. There are, of course, many different layers of agency problems, just like other jurisdictions. And one distinctive tension that is being highlighted in Korean corporate culture would be the tension between majority shareholders, controlling shareholders, and the minority shareholders. So this has been the focus of the government policies. And on the other hand, the institutional investors have been trying to solve this problem by, applying and adopting the stewardship code since 2016. And also the Korean pension fund, which is the largest institutional investor in Korea, has announced that it will when they are exercising their voting rights, they will take into consideration the ESG considerations and also the spirit of the reform, the recent Korean reforms. That is to solve the tension between the minority shareholders and the majority shareholders. So I think that's the key issue in our jurisdiction, and that's the way that it's being addressed.
With respect to the minority shareholder protection, I can't tell what is the defining characteristic of Chinese law, but the recent comprehensive amendment to our company law in 2023 and was effective in 2024. There are a couple of measures have been taken to enhance the protection of minority shareholders. For example, we extend the shareholders' information rights of the parent company to the wholly owned subsidiary companies, which means the shareholders of the parent company can request to inspect or copy the documents and materials of the subsidiary company. And another example is that we introduce a new trigger for the appraisal right when in cases where the large shareholder or the majority shareholder abuse their controlling position and damages the interests of the minorities and the company. And in these cases, the minority can request the company to repurchase their share at a reasonable price. And the final example is that we lower the shareholding threshold for submitting a shareholder proposal from 3% to 1%. These are the key measures regarding minority shareholder protection. Thank you.
So very quickly, I was told that as long as I say independent directors don't work in this forum, I'll be safe. And reform needs to be made in the context of independent directors. But a very quick point in terms of the changes that are happening in the Indian context are focused towards director disqualification, director strengthening, and board-specific powers. The controlling shareholder concept, I'll give you an example very quick example of a $1 million airline, could have been $1 million airline company that completely went down the drain because the board of directors were not able to sort of replace the managing partner of the managing director, of the company. And those are real examples of how oppression, mismanagement, or class action related provisions that exist in the Indian law have not worked. So the future strengthening on the newly tabled bill look at director disqualification, director strengthening as key. And we're looking at a more independent board model. They don't really look at independent directors, which is a transplant that we have right now, but strengthening the board seems to be the future.
Thank you. So we talked yesterday in the session about the changing landscape of ESG and CSR, and what a difference 2 years makes. Back in 2023, Alex Edmonds from London School of Economics, I think, wrote a paper called The End of ESG. And he was not saying that it was the end of ESG. He was saying that ESG is now so embedded in business models that it has gone mainstream. But of course, by 2025, there are lots of papers written about, is ESG dead? I found a December 2025 paper by Pollination, which is an Australian-based climate change and investment advisory firm, saying the death of ESG continues to be greatly overrated. So there's lots of different views about what's going on across different jurisdictions with ESG. And I want to ask the panelists, in your particular jurisdiction, is it flourishing, is it dead, or is it temporarily in hiding? And if it's temporarily in hiding, when can we see it come out of hiding again?
I see. Thank you for the question.
You've got such quiet voices.
Okay, I'll try to speak up. So I wouldn't want to think the ESG issue is either fading or demolishing. I would like to see it that we are in kind of transitional phase. I would not go much into details as it was very well elaborated in Professor Jung's presentation yesterday. But the Korean government has been trying to establish the ESG disclosure requirements with experts and inputs in it. And it has not been mandatory yet, but it's working on it. And also the corporations are preparing to meet the requirements, which will be forthcoming soon. So I don't think they will be going back, and it will go further into the future, even though it's slower than we expected.
In the context of China, ESG and sustainability development are really flourishing, at least on the law in books level or on the policy level. We have introduced the mandatory sustainability reporting regime in 2024. And it introduced, borrowed from the EU, the double materiality principle, which means the ESG information is financially material or impact material. The company is obliged to disclose them. But there exists a very big difference between China's regime and the EU's CSRD, and it's that under the CSRD, the disclosed ESG information is subject to a mandatory third-party assurance requirement, which means that this disclosed data should be assured by the third party. but such a requirement is not required. It's not mandatory under Chinese regime. So this will, to a large extent, impact the quality and credibility of the disclosed data, and in practice, in 2024, only around 8% of the listed companies which have disclosed their sustainability data obtained a third-party assurance. But by comparison, in the U.S., the U.S. law also doesn't require or mandate a third-party assurance. But 70% of the S&P 500 companies that disclose their sustainability information obtained the third-party insurance, at least for some part of the information. This is the data of 2023. So even on the policy level or on the law in books level, China is actively and eagerly embracing the ESG transition. But our sustainability reporting regime is far from well-established. Thank you.
So just very quickly, I don't think it's dead, transitory, or in hiding or flourishing. Neither of that. It's essentially based on whether the investor is confident enough to invest, if it is green-linked, or if there is a ESG mandate in the governance guidelines. We do have something called the BRSR framework for listed entities, which is directory in nature, but you do see a lot of the top 100 listed entities trying to comply with these frameworks. There is a proposition to make it mandatory, but we don't know the position on that yet. But I do want to just quickly identify that green-linked, ESG-linked financing seems to be a very, very fruitful proposition right now in India, and you do see a large amount of investments that are happening in this particular space, especially as India looks to effectively draft laws on nuclear power and has gone towards a lot of changes towards investment in power. So just a quick briefer, because we have ESG and CSR, and the question Jennifer posed also spoke about CSR. Right now, CSR models or amounts that Akshay already covered yesterday had very limited considerations. There is a proposal to reform that to make it a larger, broader mandate for large companies. So we'll see how that goes. That's the Indian position.
Well, we now have mandatory disclosure, sustainability disclosure in Australia, but that's fairly recent. It was interesting because Chitra told me that 97% of Malaysian public listed companies have now adopted sustainability governance practices. I think, Xingguang, you also mentioned ESG voting by fund managers. Do you want to say anything about that?
It's very interesting that Chinese government and Chinese securities regulators has recently issued rules governing how mutual fund managers how they engage in the corporate governance of listed companies, and in particular, the governing rules encourage the managers to pay due attention to sustainability development matters, and when the managers collectively hold over 5% of the list of the shares of the listed company, they are obliged to actively vote on the matters regarding environmental protection and other other matters concerning social welfare. Another important measure is that these rules impose a obligation on the managers to disclose the information on how they vote on the shareholder resolutions on the portfolio companies on an annual basis. And as of now, there's only one management company has disclosed their information on voting. So it's as of today, it's not clear whether such mandate can really change the behavior of the managers, especially whether such mandate or such initiatives can really enhance the supporting rate of the managers when they vote on the proposals or resolutions concerning ESG issues. Thank you.
I want to ask the panelists something about corporate purpose, because we're all familiar with Colin Mayer's work, which came out of the British Academy and was then adopted in the UK Corporate Governance Code about the need for corporations to have a corporate purpose. And he defined, the mantra of his project was that the purpose of business should be, and I quote, producing profitable solutions for the problems of people and planet and not profiting from creating problems. And there's a lot of alliteration there. It shows the value of creating a memorable mantra by using alliteration, a lot of P's. Colin Mayer thought this could have a transformative effect for corporations if it was included in their constitution. Other scholars, such as Paul Davies, and of course Colin Mayer is not a lawyer, Paul Davies is a lawyer, they thought that it would be either ineffective because it would be unnecessary, that if shareholders wanted it, they'd be pressing management for it, or it would be, counterproductive, and that, if it was the directors that had control of the constitution, they either would or wouldn't put it in. So I want to know, how important is corporate purpose in your jurisdictions, and does it look like Colin Mayer's concept of what a business purpose should be, producing profitable solutions for the problems of people and planet? Or does it look like something different? I kind of have a view, but I'm interested in what you think.
I think this is a very difficult question.
All my questions.
They are actually. So just like I mentioned, now the current focus of the commercial law reform is on the shareholders' rights. However, I think it's really different to the original or old shareholder-centric idea, because they are more focused on the minority shareholder interests rather than the majority shareholders' interests. So now the phenomenon is that the new shareholderism is kind of aligned with the stakeholderism. So it's not against the stakeholders' interests or the society, but rather the protecting the minority shareholders is being accepted by the society as protecting the society. So, and this is the way that the government is approaching, and also the institutional investors are trying to be motivated in this direction. But there is, I think, an issue left, which is that to what extent the institutional investors should take these considerations when they are making the investments, and also how can we protect the investments from having too much influence too much political influence by the government.
Actually, the China's 2023 revision of the company law introduced a new corporate purpose provision, which is the Article 20, and according to Article 20, the companies, when they conduct their business operation, they are required to take into consideration the interests of other stakeholders, including consumers and employees, and as well as other broader social interests like environmental protection. So our new corporate purpose provision shows a very strong stakeholderism, and many Chinese scholars regard it as it's a Chinese version of constituency statutes. But will such a new corporate purpose clause make any real impact on the market behavior? It's still not clear. But if we simply look at the corporate charter of the largest listed companies in China, if we look at the corporate charters of the CSI 100 index, which consists of the 100 largest stocks in China, and we can see as of today, there are still 29 of them. In their corporate charters, the corporate purpose clause said that the maximization of shareholder wealth or maximization of profits is still their sole corporate purpose. So if we look at this simple fact, I'm really doubtful of such the real impact of such a clause, and because in the U.S. it's the same situation, the real impact of the constituency statute is really not promising. Thank you.
So, extremely difficult question. Also, very difficult to answer this question in front of Umakant, who's basically a walking repository of materials. So I'm just going to quote him because I've already mentioned him. Very early on, he's written a paper that's publicly available on how much regulation, corporate governance, is corporate governance in India overregulated. And it's a fantastic paper that I assign a lot to people to read, because you see, because India is a jurisdiction that isn't very shareholder active, in 2013 a very key amendment, which is section 166, was brought in, which spoke about good faith and directors being central to governance. Then becomes the question on how much you need to effectively regulate this director so that he meets the definition of corporate purpose, good governance, good faith, and acts in the interest of a company. So think it is a very sort of case-to-case model. You are looking at recent takeovers that have happened in at least the past 10 years, very inclined towards meeting the good governance, shareholder active, directors acting in good faith. I wouldn't necessarily call it business judgment necessarily or fiduciary necessarily, but just in the intent of corporation, profit, business, saving the company. So in that sense, I do think that there is a movement towards corporate purpose, but you see so many years of governance in India has been ad hoc in nature that you can't sort of have an overnight corporate purpose reform.
Well, I think those are very interesting comments. I would say constituency statutes in the US, I don't think of having anything to do with corporate purpose or ESG. I think of that just as protecting management to, do what they like in the face of takeovers. And I think I think you're right, the focus in Asia is either still on our main purpose is to make money, or a kind of stakeholderism, which is different to Colin Mayer's. Now, I've got other questions, but I do want to throw it open to the room. Steve tells me I have 8 minutes, or we have 8 minutes, it's not me. And 7. Thanks, Steve. Kenneth, ask your question, please.
Thank you so much, Jennifer, and the panel for excellent discussion. So I have a question concerning, a kind of provocative question concerning whether corporate governance matters. So in the following sense, so like most of this room, I've done some work, earlier work with Roberto Tallarita on the effect of SB 21. And in fact, we showed that SB 21 did indeed induce a reduction in firm value amongst controlling oriented firms. So dual class share firms, firms with large controllers, also all of these firms, including Delaware firms, experience a relatively larger decline in firm value. On the other hand, if you speak to someone like Ronnie McLeay at HKU, and if you look at the recent work that he has done on, let's say, Chinese investment managers, the central theme that comes out is that investors rank very low on the analysts' predictions of firm value. So what the investors think don't really matter. And in a very new paper that I've just written with Hunt at NUS, we basically show that in Singapore, using a proprietary data set of SGX and MAS data, that governance did not matter at all. So I'm wondering if there's something going on in the sense that when we speak about minority shareholder protection, is there really some kind of do you really think that it matters in the grander scheme of things, or do you think that it's instrumentally important, as what Mariana Parjand has suggested, that participation is an intrinsic good and therefore we should promote it regardless of firm value?
Okay, so first question is corporate governance overrated? Does it matter at all? We're going to collect the questions and then you can all answer, or Steve won't let you answer, whatever.
So this just builds on Kenneth's point, and I guess this is for Professor Lee and Professor Zhou. Ostensibly, it looks like Korea has made these huge changes, right? So extending the fiduciary duty from the company to shareholders seems like a big deal. Cumulative voting seems like a big deal. But I guess this is related to Kenneth's question. How much do you actually think that these things will change things in practice? It seems like the duty wouldn't change things much. It's just sort of a political statement. And then again, in the China situation, the double materiality move seems like super significant, right? It seems like a Beijing effect instead of a Brussels effect, or China coming into line with the EU. But then when you talked about the lack of the audit of this, right, it seems like it may not actually have any impact. So I guess it builds on Kenneth, but on those two particular points.
Is corporate governance overrated, and does it have any role to play? Okay, here we have Jordan.
Yeah, so first answering to Kenneth's and Dan's question. I was not intending that, but I'm doing writing a paper with finance professors at Seoul National University, and the answer is that the change of duty of loyalty have some causality with the dramatic rise of stock prices nowadays. We are not really sure about cumulative voting because, as you know, there are mixed voices in the board of directors. So we are working on that, and we'll be happy to share with you for comments. It would be appreciated. So my question to the panelists is that I understand the influence of retail investors in 3 countries are really, really enormous. In the United States, we've been talking about meme stock, but it's only limited to small number of companies, while in India, China, and Korea, I understand that retail investors are investing a huge amount in the market. And what do you see about the influence of these retail investors to corporate law and governance?
Okay. So, who would like to talk about the influence of retail investors, and who would like to talk about does corporate governance matter at all? And I think the does corporate governance matter leads into something that Chitra said to me. She said, look, in Malaysia, it's all about enforcement, and the enforcement is hopeless. So, the question goes to, does corporate governance matter without the enforcement being there? And if the enforcement's there, does it matter? And what's the influence of retail investors? I know you had something to say about that, Haemin.
Thank you.
And shareholder activism.
I see. Just to briefly touch on the corporate governance issue, I think it's probably my observation, but what I observe is that there is some commonality, but also divergence between jurisdictions. For instance, in the U.S., in the state of Delaware, we are witnessing some legislative changes recently, just like you mentioned, and SB 21. But the difference is that we could say that was a more pro-management, and there was kind of a backlash to some judicial decisions. And I see the difference. It is based on the differences that there is a charter competition in the United States. So the state is trying to attract the corporations to incorporate in their states. On the other hand, in Korea, we do not have charter competition. Instead, we need to attract investors, especially to retain the retail investors into Korean market. So we are now focusing on corporate governance. We are trying to give the message to the market that we are actually improving the corporate governance, and that is actually working. So I think it really is working, and it matters here now. And also in the role of very briefly on the retail investors, and I do not think they are very focused as to exercise their voting rights to change the corporate governance. But however, just because they are very big enough to be the voters in the political areas, it is enough to make it a political priority for the politicians, and it eventually made the changes in the commercial law. Yeah, I hope it.
Thank you. So for the first question, whether does corporate governance matter? From my perspective, if you look at the PE market for the private equity managers, of course, their primary objective is financial returns, but they also request some influence or some right, especially the veto rights, in the agreement with the company to exert influence on or have some say on the corporate governance, and even such said letters or agreement has been challenged in recent years in the U.S. Courts, and also raises questions in the Chinese context. And the second question is regarding the double materiality principle. Of course, this real impact. It's also a really foundational revolution in the securities disclosure regime, but whether it can make real impact relies on the other issue I raised is about the third-party assurance. If the disclosed data is not subject to any outside review, so the real the effect will be largely discounted. And the third question is the influence of retail investors on corporate governance or corporate law. I think under the traditional framework that corporate law or especially securities regulation should pay more attention to the so-called information traders, not and if I think from my perspective, if the proportion of the individual shareholders is too high, it'll make too much noise. So I'm not sure whether from the policy perspective or as a regulator, we should have rules or policies to lower such proportion, or to encourage retail investors to go into the capital market. Thank you. I'm not sure.
India is a little different from both the jurisdictions because there is a lot of security law and governance with respect to voting, veto, exit, etc. when it comes to retail investors, because it's a huge market, and the Securities Exchange Board of India has come up with a lot of regulation that effectively allows that kind of control. And also to not allow that kind of control. So there's a bit of a dual in there. Corporate governance matters. I think today in India, a lot of ex ante measures are being taken so that there's a real fear of distress and losing money, let's put it that way. And because of that, you need ex ante governance. So a lot of law is being conditioned as to, the fear of losing money is really real. The new, just to a last point, because I am predominantly a bankruptcy person, there is also a real fear to go into bankruptcy in India because the trigger is actually very default based, and then you lose control. There is complete loss of control the minute you go into bankruptcy. So there is that consideration as well that makes governance important.
Thank you for those answers. I thought they were really fascinating and insightful. Just a couple of things that came out. Haemin's point about the difference between, the US, which I think historically has been very pro-management, versus UK corporate governance, which has been more pro-shareholder. And I remember Deborah DeMott saying that many years ago. These are different ends of the spectrum. And then, your idea as well, Ishana, that I think UK corporate governance was always based on fear of losing money, fear of, corporate collapse, whereas the US, I think, interprets corporate governance as how to have superior performance. And those are very different lenses to look through. So thank you. These have been, really, you've been great, because I threw them all these hard questions like a day ago, and they said, we feel like we're sitting in exam, and I said, well, just enjoy. So thank you so much for being such good sports, and thank you.